Many couples believe they can come to the United States on a tourist visa, get married, and then simply apply for a green card. But entering the U.S. on a tourist visa with the intention of marrying and filing for adjustment of status can create serious immigration problems, and in some situations it can even be considered misrepresentation. So what is actually legal, and what should couples be careful about? Welcome to Coffee with Richard. I'm Richard Herman. I'm an immigration attorney with more than 30 years of experience helping families navigate U.S. immigration law. Today, over coffee, we're talking about one of the most common questions couples ask. Can I marry on a tourist visa? Let's break it down. This is really about non-immigrant intent versus immigrant intent. Let's start with an important distinction. There's nothing illegal about getting married in the United States while someone is visiting on a tourist visa. People get married here every day while traveling. The legal issue is not the marriage itself. The issue is immigrant intent at the time the person is entering the United States. When someone enters the U.S. on a B1 or B2 tourist visa or through ESTA under the Visa Waiver Program, they're telling the U.S. immigration official that their visit is temporary, based on tourism, visiting family or friends, or attending a business meeting. They are not supposed to be entering the U.S. with the plan to immigrate immediately. If someone comes to the U.S. already intending to marry a citizen and apply for a green card through adjustment of status, immigration authorities may consider that misrepresentation at the border. And misrepresentation can have very serious immigration consequences. Now, you should be aware of the 90-day rule. You may have heard about something called this 90-day rule. This is a guidance issued by immigration officials when they are evaluating whether someone misrepresented their intentions when entering the United States. The basic idea is that if someone enters the U.S. on a temporary visa and then very quickly takes steps towards permanent immigration, such as marrying a citizen and filing for a green card within that first 90 days, immigration officers may question whether that person intended to immigrate all along and go around the legal process from going through the embassy for an immigrant visa. Now, the 90-day rule is not an automatic denial rule, but it can trigger additional scrutiny and questions about the timing of the relationship and the original purpose of the trip. ESTA entry risks. This issue can be even more sensitive for travelers entering the U.S. under the ESTA program, the Visa Waiver Program. ESTA allows visitors from certain countries, like the UK or France, to enter the U.S. for up to 90 days without a visa. However, travelers entering the U.S. under ESTA generally waive certain rights, including the ability to challenge removal orders before an immigration judge in many situations. Because of that, couples should be especially cautious about planning immigration strategies around ESTA entry. For example, if someone overstays their entry, even if they marry a U.S. citizen, USCIS may not care that much about the overstay, but ICE and Border Patrol certainly would, and they could technically arrest that person and put them into expedited removal, which means removal without seeing a judge. So ESTA cases require special planning and caution. Now, budget and time. Another important factor that couples should understand is the cost and timeline of the process. Marriage-based green card cases involve several government filings. These often include the I-130 petition, the I-45 adjustment of status application, work authorization requests, which is the I-765, biometric appointments, and a medical exam. Government filing fees alone can total several $1,000s, and processing times today often range from roughly 12 to 24 months, depending on the circumstances and the location of the case. Now, documenting a real marriage. Couples should also start collecting documentation showing that their relationship is genuine. Immigration officers want to see evidence that the marriage is real and not entered into solely for immigration purposes. Examples include photos together, travel history, joint bank accounts, shared leases or housing insurance policies, and communication records. The stronger the documentation, the smoother the process tends to be. Final advice. So the key takeaway is this. Yes, you can legally marry while visiting the United States on a tourist visa. But entering the U.S. with the pre-planned intention of marrying and immediately applying for a green card can create immigration risks. Issues like intent, timing, to entry, documentation, and overall strategy all matter. If you or your partner are thinking about the marriage green card process, our team at the Herman Legal Group has been helping families navigate immigration law for more than 30 years. You can reach us at 1-800-808-403 or our website, lawfirmforimmigrants.com. And you can schedule a consultation and we can discuss all the issues. Thanks for joining me for a cup of coffee and discussing the marriage green card process. Good luck and hope to talk to you soon. Bye-bye now.